So the Texas Suppressor Freedom case, which aims to stop the NFA and ATS regulation of suppressors, was just thrown out of federal court. So let's talk about this. But real quick before we jump in this video, if you think the NFA and GCA need to be done away with, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. If you purchase one of their dedicated roasts for GOA or FBC, some of those proceeds go directly to those organizations so they can file lawsuits and challenge these types of laws. So again, if you want amazing coffee and you want to support a company that supports the Second Amendment, I highly recommend Blackout Coffee. And if you use the code ARMSCHOLAR, you can get 10% off of your order. Links to Blackout Coffee will be down below in the details section and also in the pinned comment. As I mentioned in the intro, in this video, we will be discussing the Texas Suppressor Freedom lawsuit, which aimed to eliminate the NFA and ATS regulation of made in Texas suppressors. The case we will be discussing is prior known as Paxton v. Dettelbach. This was an important and interesting case that was set to be decided on cross motions for summary judgment. All indications coming out of the hearing on those cross motions was that things didn't really go super well for the Pro 2A side, and we just were proven correct by an order that we got from the federal district court judge. Today, the federal district court issued an order granting the ATF and the government's motion for a summary judgment, which ultimately has dismissed this case for a lack of standing. To me, this opinion reads as a big cop-out by the federal judge, which is usually the case when something is thrown out because of a lack of standing. Usually a lack of standing is used whenever a court does not want to actually review an issue or deal with a controversial topic. Here, the court ruled that none of the individual plaintiffs have an injury in fact to meet the standing requirement. Also, the court found that Texas cannot stand in the place of its residents to sue the government to stop the application of the NFA towards made in Texas suppressors. Now, for those not aware, this lawsuit arises out of Texas House Bill 957. HB 957 aimed to exempt from federal regulation all suppressors that are made in and remain within the state of Texas. The claim behind this law is that since these items are made and sold exclusively within the state of Texas, they do not fall under interstate commerce and therefore fall outside of the purview of federal regulation by the ATF. Then Texas, along with individual plaintiffs, decided to file a lawsuit against the government, and that's what led to this case. This case was then ultimately submitted to a federal court on cross motions for summary judgment, and then last month there were arguments before the court on whether or not the court would grant the plaintiff's motion for a summary judgment, whether or not they would rule in favor of the individual plaintiffs in Texas, or would they grant the motion for summary judgment in favor of the ATF. Well, we received the court's order today. The court ruled in favor of the government under the rationale that the plaintiffs lack standing to bring the lawsuit. Under the concept of standing, legal actions cannot be brought simply on the grounds that an individual or a group is displeased with the government's action or a law. Federal courts only have constitutional authority to resolve actual disputes. Standing has three basic requirements. First, there must be a concrete injury in fact that is not conjectural or hypothetical. Second, there must be causation or a fairly traceable connection between the plaintiff's injury and the complained conduct of that defendant, here the government. Third, there must be redressability, essentially a likelihood that the requested relief will redress the alleged injury. Without standing, a legal action cannot proceed forward. The judge stated that individual plaintiffs are correct that the government has a history of prosecuting the illegal possession of unregistered silencers, but these plaintiffs have adduced no evidence that they in fact possess any illegal silencers or otherwise attempted any prohibited conduct, nor have they shown that they have been threatened with prosecution or that is going to be likely. And our doctrines of criminal law forbid convicting persons for mere thoughts, desires, or motives. Individual plaintiffs therefore failed to allege a substantial risk of prosecution based solely on the desire to do something the government has prosecuted in the past. So individual plaintiffs' fear of prosecution is imaginary or speculative at best and insufficient for Article 3 standing. That is what the judge said in regards to the individual plaintiffs and what he believes is a lack of standing for those individuals. Here, the judge is essentially stating that the individual plaintiffs would have to allege that they possess an illegal silencer or that they engaged in some other prohibited conduct that the ATF claims is illegal. The court also says that the plaintiffs could show standing through evidence that they have been directly threatened by the ATF in regards to making homemade suppressors. In this section, the judge says that the legal standard for pre-enforcement challenges to a criminal statute is something that demonstrates a realistic danger of sustaining a direct injury from its enforcement. But the position the judge takes is that even a showing of intent to violate the law would not be enough. Instead, you would need a plaintiff who decides to fall on their own sword for the greater good of the 2A cause, engages in what is deemed illegal conduct, to then have standing to sue the ATF. The judge also stated in his opinion that alleging that the law is unconstitutional and impacts Second Amendment rights is not enough to remove the burden of establishing standing. The judge states, individual plaintiffs have not attempted to apply to make and register a silencer, and assuming that they are correct about the unconstitutional nature of the requirements, it is immaterial whether an application is ultimately approved or denied. Either an application is wrongfully denied and a plaintiff is injured because the government has deprived them of a silencer, or an application is approved and the plaintiff is injured by being subjected to the process and tax. But individual plaintiffs' intent by itself to make a silencer in violation of these requirements fails to establish that they have been concretely injured by the process they seek to challenge. Again, this judge is positioning this case as if the person must subject themselves to the serious criminal prosecutions just to be able to sue the government over that type of unconstitutional process. They must essentially subject themselves to the process that they want to challenge. Then the court goes on to address whether the state of Texas on its own has standing as well, and they find that the state of Texas does not have standing to sue the government. The judge states, by its own words, Texas seeks to protect the ability of its individual residents to make firearm silencers at home. The only purported link between the state of Texas and the GCA regime is Texas's state statute exempting silencers from the operation of federal law, and the supremacy clause of the Constitution determines the winner of that duel. Texas may not merely litigate as a volunteer to the personal claims of its citizens, and it's hard to think of a more personal interest than one's ability to better hear a home intruder in the middle of the night and fend them off with the aid of a homemade silencer. Texas is thus seeking to sue the federal government as parens patriae on behalf of its residents to vindicate their personal Second Amendment rights, regardless of whether it wants to admit it. And then the judge says that makes this issue open and shut. Now, to me, this section was pretty frustrating to read. The judge inserts a comment as if he's recognizing the importance of an individual having access to homemade suppressors for self-defense, having the right to protect themselves with these types of devices, but then says that the state cannot assist the residents in protecting their Second Amendment rights, engaging in this lawful conduct, or what I believe should be lawful conduct. And earlier, he also says that the individuals here could only sue the state, could only sue the government essentially here, if they first open themselves up to criminal prosecution. And based on all of that, the judge then grants the government's motion for summary judgment and dismisses the case in favor of the ATF. Now, by no means is this case dead in the water. There are two options really going forward. The state of Texas can, of course, refile the case with plaintiffs who are willing to expose themselves in the way that the judge wants them to. Maybe even with plaintiffs who have concrete claims of intent to make a made in Texas suppressor or some sort of potential threats by the ATF or the government against homemade suppressors directly against those individuals. But more likely, though, I suspect that the state of Texas will appeal this decision up to the Fifth Circuit. They will simply just appeal this summary judgment motion in favor of the government. They'll just appeal that up to the Fifth Circuit. It will go to the Fifth Circuit level, and then the Fifth Circuit will decide whether or not the judge committed an error in dismissing the case for a lack of standing. So definitely an unfortunate loss. I think the judge here did not want to deal with this controversial topic at all about suppressors, NFA items, interstate commerce, and what the Second Amendment protects as far as homemade suppressors. So he took the easy route. He took the easy way out that most judges do in just saying that this case does not have standing so that he can essentially get out of having to rule on this issue. But unfortunately, that's where this case currently stands. Now, if we get any more information, of course, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in the Cyber 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.